So good morning to those of you who are physically present here with us in the conference room, and also to those of you who are joining us via the live stream. I want to welcome you to the UCI Law Conference on the Discursive Turn in Copyright. My name is Dan Burke. I teach intellectual property here at the University of California, Irvine, where I was a founding member of the faculty of the law school about 9 years ago now. And when I first arrived at UC Irvine 9 years ago, the big question in Orange County and in California and in the UC system was, what does California need with another law school? What does the UCI campus need with a law school? And there were a number of persuasive answers to that, but one of the answers that I was given by the provost and by the chancellor here on campus at the time was that part of the plan for the campus was to have a law school as a focal point for all of the legal and law-related scholarship that was already happening on this campus. So if you looked around the UCI departments, you could see that there was very significant research and scholarship happening in psychology, in the business school, in criminology, and certainly in the humanities, in English and in philosophy related to the law. And it was desired to have a focal point, an interdisciplinary crossroads, so to speak, for all of that research to happen. So there's been a great deal of interest since we've been here in interdisciplinary work. Particularly the last few years, there have been a number of initiatives to partner with our departments in the humanities on the humanities and law, and this conference is part of that outreach. Copyright law is, of course, the mechanism that's provided in the United States by the Constitution and around the world in many countries to try and foster expressive types of works, art and music and literature. And so it's not surprising there's a close relationship between copyright and the humanities. And it turns out, since turnabout is fair play, that the humanities, theories of literature, theories of art can teach us a great deal about how copyright should work. And that's really what we're doing here today with a really stellar lineup of legal and humanities scholars to talk to us about different aspects of copyright and literature and art and the humanities. So a conference like this, of course, doesn't happen without a great deal of work behind the scenes. There are lots of people who have been very important in putting this together, making this happen. People from the communications department of the law school, from finance and from information technology. One person in particular, who many of you have already corresponded with and spoken to, is my assistant, Adelina Tomova, who was here just a moment ago. Yes. Adelina, would you step up here for just a second, because sometimes you leave this to the end and everyone's tired, but we want to thank Adelina now. She has really been a key person in making this whole conference come together, and we're extremely grateful for all the dedication and attention to detail that she's provided for us. Thank you again. So our first session this morning, we are very pleased to have Professor Laura Heyman from the College of William & Mary, who will be speaking to us, and then Kavita Phillip from UCI here on campus, who will be commenting. We're going to hear from Laura for about 20 minutes, and then we're going to hear from Kavita some commentary on Laura's paper for about 15 minutes. I'm not going to go into extensive introductions because you have either on the website or in your program some detailed biographies, and we could literally spend the entire day talking about the accomplishments of our speakers. That would be an interesting conference in itself, but that's a different conference. So please have a look at that. But those of you who are particularly interested in CLE credit will notice that we provided some of Laura's past work on reader response theory as suggested CLE materials, background materials, and we are very much looking forward to hearing her newest work on that topic. Laura Heyman.
Great. Well, thank you so much, Dan, for that kind introduction, and to Adelina and to all of Dan's colleagues here at Irvine for putting together such a good conference. I look forward to learning a lot. So the question I'm interested in is how literary theory and particularly reader response can help inform the transformativeness inquiry in the first fair use factor. So the idea, as the court held in its 1994 opinion in Campbell versus Acuff-Rose, that fair use can involve consideration of whether the defendant's use of the work adds new meaning or message to the plaintiff's work. I am going to assume, given the limited time that I have this morning, some familiarity with basic principles of copyright and with fair use, and so I apologize if there are those of you in the room who will be a little bit in the dark as a result of that. So in the years since Campbell, but before the Second Circuit's 2013 opinion in Carey versus Prince, courts typically determined whether a work was transformative by comparing aesthetic attributes or the defendant's activity or purpose. Yet in Campbell, the court used a particular phrase. It stated that, at least with respect to the claimed parody that was at issue in that case, that the threshold question in transformativeness is whether a product character, as a parody in that case, may reasonably be perceived. So in Carreyrou, involving a claim by photographer Patrick Carreyrou against appropriation artist Richard Prince, the Second Circuit shifted the focus of the analysis accordingly, stating that the key to the transformative analysis is, quote, how the work in question appears to the reasonable observer, not simply what an artist might say about a particular piece or body of work. And this result must have come as a great relief to Prince's lawyers because their client refused to give any statement of his artistic purpose on the record. So the Carreyrou court's focus on transformativeness from the perspective of the reasonable observer rather than from the perspective of the author or artist aligns, in my view, with a reader response view to the transformativeness and a reader response approach to the transformativeness analysis, focusing on whether a work has a distinct meaning or message, not by reference to authorial intent, but rather by looking to audience interpretation. And the Carreyrou court, like many but not all courts since, take on that task without much in the way of explanation as to why its conclusions are those of a reasonable reader or a reasonable observer. In that case, the court concluded that 20 of the 25 works that were at issue in this case were on their face transformative, based largely on the court's perception of aesthetic differences between the two, and sent the remaining 5 works back for consideration by the district court, and the case then settled. But given the possibility that judges might act, in Rebecca Tushnetz's words, as bad reviewers, in that their biases might lead them to disregard the possibility of alternative interpretations, is there a better approach? So when we say that the reading must be reasonable, that actually might be taken to mean by some that interpretations that the court or a dominant interpretive community finds transgressive in some way would be outside artistic and therefore legal boundaries, as Andrew Gilden and Timothy Green have highlighted. So I do think that this task of interpretation by courts should be taken by the courts with awareness that what they are doing is aesthetic interpretation, as Fred Yen has mentioned with copyright more generally. And here I mean something more than simply an awareness that other viewpoints exist. So Brian Richardson reminds us that if we conceive of the reader as a unitary being, with no gender or race or sexuality or socioeconomic status, that actually will serve to minimize the very real experiences that individual readers bring to a reading. And in previous work, I've made that same observation regarding judges in trademark law cases. So when judges are trying to figure out who is the reasonable consumer, they will sometimes see the reasonable consumer as having the same visual acuity or dialect or literacy level as a judge does, which is not always the case. So here I mean a more deliberate, overt recognition by the court of its function as a reader in conversation with other readers of the same material, at the same time that the court is functioning institutionally as an adjudicator. So let me unpack this just a bit. Why does it matter that how the work in dispute appears to a reasonable observer, or whether any new meaning or message may reasonably be perceived? So when we talk about a reasonable person in tort law, more generally, we're referring to a legal construct that sets a standard of care. So from a law and economics perspective, when we say someone has to act reasonably, we're saying that that person should only take those precautions that are cost justified. So if you would hire around-the-clock security personnel to guard against a microscopic chance of injury. That is too much cost, and we would say to require that would be unreasonable. From a distributive justice perspective, we might say taking reasonable care inheres in what we as a community expect from one another in light of generally accepted individual limitations. So we expect those who create a risk of harm to others, let's say by driving a vehicle, to take care to avoid injury to others, but we don't expect a child to be able to take that same level of reasonable care as an adult would. And in trademark laws, I mentioned we see the reasonable consumer as determining what is lawful or unlawful behavior for a putative infringer. And as in tort law, we don't expect defendants in trademark cases to incur the cost of minimizing confusion for consumers who act unreasonably. So we see similarities. If a consumer sees similarities where other people would not, or who refuse to notice something that's directly presented to them, it's not that the experience of an unreasonable consumer is invalid or untruthful. It's just simply that we don't require defendants to take their views into account. But what work is reasonableness doing in a transformativeness inquiry? So the limitation of viewpoints on transformativeness to those that would be seen by a reasonable observer can't be meant to guide the defendant's efforts, as in other tort law scenarios. So when a court finds fair use based on transformativeness, it's not saying that the defendant acted reasonably in her artistic choices or that she took cost-effective precautions to avoid encroaching on the plaintiff's rights. If anything, that consideration would attach to the third fair use factor, which is asking whether the defendant took too much of the plaintiff's work for her purposes. Nor does that limitation seem related to the mode of the defendant's argument. So if we were focusing not on the reasonable observer, but on the defendant's purpose, we might then ask whether the defendant's use of the plaintiff's work was reasonable in light of that intended purpose or justification. But from a reader response perspective, what would an unreasonable observer conclude after viewing two works? So if the works of Richard Prince or Sherry Levine that you may be familiar with, appropriation artists that often appropriate wholesale the works of others, would be considered transformative by some in the who have knowledge of contemporary art, what conclusion as to transformatives would be unreasonable, given the breadth of discursive and interpretive communities in the world? So the use of reasonableness as a limitation thus, to me, seems to be designed to encourage courts not simply to offer conclusions, but to offer reasons. To discuss, as part of an interpretive community, the aspects of the two work that led the court to conclude that the second alters the first with new meaning or message, and ideally to respond to views that conclude otherwise. And by reasons, I don't mean justifications. So the court is not being asked to square its interpretation with an existing rule or principle. In fact, the nature of the transformative inquiry makes it difficult to derive any larger principles from a particular case beyond the definition of the term in any event. A reader-focused view of interpretation entails reasoning because it involves a discursive process by which readings are contested among interpretive communities. And providing reasons for settling on a particular interpretation is what makes possible the discourse that I contend the transformative inquiry contemplates. Now, in using this language of discursive or interpretive communities, I've been, of course, invoking Stanley Fish's much analyzed and admittedly often critiqued view of interpretive communities, of which Janice Radway's pioneering work on romance novels is but one example. Fish's theory, in the extreme way it's often presented, does run the risk of seeming hopelessly relativistic, right? Because all interpretive activity results from strategies that are employed by an interpretive community of which the reader is part. Under that view, no reader actually has agency. All interpretive activity is the engagement of contested readings of a work. Nothing has any primacy over any other. It's all about to the extent to which a proponent can persuade, either through argument or through power, that their argument or their view is the better one. And this result, coupled with the difficulty in defining an interpretive community in any way except by the way in which it interprets a particular work, often leads commentators to characterize the theory as unhelpful. But recall what we're trying to do here. So when a court is asking whether the use of a work is transformative, right, and therefore potentially a fair use, the inquiry is not asking a court to determine the meaning of a particular work in the same way that a court would be asked to determine the meaning of a statute, for example, and then that meaning would control for future interpretations. Rather, the inquiry is seeking simply a degree of difference between interpretations, right? And that question is itself necessarily relativistic, right? So we don't need to actually take the theory, Fish's theory, in its strongest form here. I do think, though, it requires courts to be conscious of their interpretive strategies as an institutional matter. So is there, under this kind of theory, an unreasonable reading of a work? So Louise Rosenblatt's work, which has recently been highlighted by Zahra Said in her copyright scholarship, tells us that to be viewed as reasonable, a reading has to be cued by the text. So it would be unreasonable under that theory for a reader to interpret a Shakespeare sonnet as a murder mystery, or to interpret the Mona Lisa as conveying the story of the invention of the driverless car. Right? But Fish would say that the boundary between reasonable and unreasonable doesn't actually exist of its own accord. It's simply that the activity of interpretation determines what the institution accepts as appropriate. So he says, and I'll have an extended quote here, quote, "The interpretive community is a device of interrogation, and what it promises and delivers is a method. So once a question has been framed, the interpretive community thesis tells you that in order to answer it, you should attend to the relevant background conditions, assume definitions, notions of evidence, locations of reputable archives, storehouses of legitimate arguments, the sense of what we do around here and what it is not our business to do." Now, this does not mean, that's the end of the quote there, this does not mean, though, that everything is indeterminate as a practical matter. So within the world of textual interpretation, there are some interpretations that just about everyone agrees on. So the interpretation that the phrase that is set apart at the first page of an article is its title, right? So that is an interpretation that we have all sort of converged on as an interpretive matter. And so too in the transformative inquiry, there are going to be certain examples where, if only perhaps asymptotically, the interpretation approaches that level of consensus. So maybe quoting 2 or 3 sentences of a book in a book review would fall into that category. That is a community practice that is so ingrained that few people at this point would even think to challenge it. But put differently, as Gerald Graff writes, appealing to the evidence to settle disputes about what is in the text works only if there's a consensus about what the evidence is. So it is interpretation all the way down. So what that means for a transformative analysis is then for a reading to be reasonable, a court in its role as a legal adjudicator should set out the priors that helps us understand what the court is doing as a matter of interpretation and the methods of the interpretive community of which the court is a part. Now, it should not go unobserved that the mere ability to say that an interpretation is reasonable or that of a reasonable observer as a legal matter and have that declaration treated as authoritative is an exercise of power, of institutional power. And we're going to have different interpretations be given different authority in that regard. So one example, if you're familiar with John Cage's work, 4 minutes, 33 seconds, that's a score that basically consists of directing 4 minutes and 33 seconds of silence by the orchestra, so that you just hear the ambient noise for that time period. There's a great video by Stephen Colbert of a cat performing this. It's excellent. I encourage you to check it out. It was years after its first performance before the work was actually recognized by the art world as a musical work, even though Cage wanted to attach that label to it from the outset. Likewise, the hierarchical position of the artist who appropriates might succeed in narrowing or eliminating the nature of the conversation. So an artist who parodies or otherwise appropriates a well-known work might be seen as more easily as starting a conversation around meaning. The meaning of a work that is sort of long embedded in our critical consciousness might be assumed rather than interrogated. So if we're criticizing a work that everybody knows, that might be seen as more obviously oppositional and therefore as a reasonable observer would see as transformative. But let me give 2 examples just to sort of illustrate the complexity here, and I think the nature of how these inquiries can go, such that I think it's important for courts as a reasonable observer to give reasons. So one example you may be more familiar with, one example is a little bit older. The more familiar example involves an exhibit as part of the Whitney Biennial this past spring, where they exhibited a 2016 painting by the artist Dana Schutz. The painting was titled Open Casket. And it engendered immediate controversy. It was an abstract representation of the now famous photograph of 14-year-old Emmett Till, lying in his casket after having been savagely beaten by a Mississippi lynch mob in 1955. If you've been following the news around this, the white woman who had accused him only this year recanted her story. In contrast to the starkness and the horror of this black and white photograph, which his mother had released to Jet magazine because she wanted the public to see what had been done to her son, the portrait by Schutz had made his face much more abstract, and it was actually rendered in more vivid colors as opposed to the black and white photograph. The reaction from some members of the artistic community was swift. There was a letter co-signed by a number of artists that actually called on the Whitney to destroy the painting. The artist Parker Bright protested by standing squarely in front of the painting during the show's opening weekend, wearing a gray T-shirt that said on the back, "Black Death Spectacle." Many reactions in opposition, but one theme among this was that Schutz had merely been exploiting the photograph for her own fame, and that she had not, in fact, contributed any new perspective or meaning to the photograph. Now, that view got challenged, but essentially what those commentators were saying is that she had not, in a legal sense, transformed the photograph in any real way. The Whitney, for its part, responded by changing the label next to the painting to reference the controversy and included an artist's statement. So that's example one. The second example might be a little less familiar. It involves the African-American jazz vocalist Maxine Sullivan in 1937, who started a vogue, as Life magazine phrased it, by singing the familiar Scottish song Loch Lomond as a swing number. And Life magazine noted that her recording, quote, became a favorite of the college boys and set jazz bands to swinging every folk tune from Annie Laurie to Funiculi Funicula. The nightclub reporter for the New York Times, apparently that was the beat then, wrote that her version met with approval from the likes of Benny Goodman. But in March of 1938, when she sang the song as part of a CBS radio show, a station manager in Detroit took her off the air in the middle of the song because he said, quote, it was sacrilegious to swing a traditional song. Now, it might have been the case that his objection was a publicity stunt, right? He was just trying to gain some notoriety around this. But the implications of his position didn't go unnoticed. The Afro-American newspaper in Baltimore wrote at the time that it had called attention 4 years earlier to the fact that African-American spirituals had been used as the basis of dance tunes, and no reaction from the white community at that time. And now it seemed that the tables had been turned when the old Scottish tunes had been used. So on their face, these two scenarios, separated by 80 years, both involve acts of appropriation objected to by audiences, but perceived very differently by modern commentators because of the position of the artist. So for Schutz, commentators in opposition saw her not as engaging in conversation with the original photograph, but essentially as erasing it, right? Not transforming, not having done the work to transform the photograph in the same way that copyright talks about. And I should be clear, these aren't examples that involve copyright suits, or to my knowledge, we're using these as proxies. So there are two editorial writers in the New Republic that called for the painting's destruction because they said that the people who took that view shouldn't be seen as censors. Here, and the quote from the writers is, hear their open letter as a call for silence inside a church. How will you hear the dead boy's voice if you keep speaking over him? And I should note that the Carrier Corps, perhaps I think unaware it was doing so, but offered sort of a similar assessment in its description of Richard Prince's appropriation of Carrier's photographs when it characterized the blue lozenges that Prince painted over the eyes and mouth of the Rastafarian man in the photograph as, quote, creating the impression that the subject is not quite human. But for Sullivan, her appropriation is interpreted by modern commentators as finding a voice, not erasing one. Writer Patrick Burke, for example, characterized her work as reinforcing to skeptical audiences at the time that African-American musicians would be artists and not simply performers. Now, the point in offering these two examples is not to suggest an equivalence or that either the reactions of the commentators in either of these cases should lead a court to consider those appropriations as not transformative, were that to be before the court. But rather it's that a court engaged in the process of giving reasons for a conclusion that a work is transformative fair use rather than an infringing derivative work, as perhaps either of these could have been considered, might take account of these types of interpretations in determining what a reasonable observer might perceive. So were Schutz or Williams adding new meaning or message to the original works, or were they simply using the works merely to get attention without doing the work of transformation, in the words of the Campbell court? And we can actually add to these two examples Campbell itself, in which the court, if you're familiar with the case, having found 2 Live Crew's Pretty Woman to be a transformative parody of Roy Orbison's Oh Pretty Woman, but then remanded for further consideration of whether the former was nevertheless a market substitute for the rap version of the song, and thus potentially unlawful. So transformativeness, to the extent that it remains part of this fair use analysis in copyright, is first and foremost an interpretive exercise. You could evaluate whether a work has been transformed through a comparison of features, aesthetic or otherwise, much as you might use the word transformed to describe a house renovation. But the use of transform in the fair use context, if we talk about it in that way, makes, I think, the first factor look too much like the third, which talks about the amount of the copyrighted work used. Rather, the first factor, by focusing on the purpose and character of the use, is asking something different. It is asking how the defendant's work contributes in a different way to promote the progress of science from the way the plaintiff's work does. And as the court indicated in Campbell, that requires consideration of how the works are perceived. And that requires an open consideration of the views of interpretive communities. Courts that don't situate themselves as part of an interpretive community and acknowledge that they are necessarily in engagement with other communities risk having their transformative decisions seen as a fait accompli rather than as a result of background, timing, and environment, what the court brings to the table and what it sees out there in the world. So this is the way, I think, to give meaning to the concept of a reasonable observer, or meaning that may reasonably be perceived, in a world where every interpretive community has the ability to contest meaning. Putting engagement on the record recognizes that transformativeness is cause, not effect. That transformativeness in a work is ultimately not what it is, but what it does. Now, the result of this might well be that fair use disputes will be less frequently resolved at earlier stages, and courts may need more record evidence and more expertise as to the views of interpretive communities. I recognize in saying this that the cost of all this would not be mine to bear, but I do think it is the better outcome for the development of fair use doctrine. And so with that, I'll stop, and I look forward to Dr. Phillips' comments.
Can you hear me, or, oh, you need me to wire up too? I assume for this. While I wire up, I want to thank Laura for a brilliant paper, which I'll say more about in a minute. And I also want to thank Dan and Adelina and all my colleagues at UCI who made this happen. I've had the advantage of reading Laura's paper, so I'm going to dwell on the footnotes and things that she couldn't bring to our attention. But as I start, I want to note a couple of things in opening. I will make the first claim that I think Laura's paper is radical. She's presented it to us today as a very reasonable paper, and she's put us in the position of reasonable observers, reasonable readers of her paper. But I'm going to argue that, in fact, she wants us to be more than reasonable readers. She wants us perhaps to be unreasonable readers, and I want us to raise the specter of unreason, politics, and an unruly public, something that challenges the very specter of the public sphere, which lurks in the margins, in the footnotes, and on the sides of your very reasonable suggestion that courts get to know a little bit more about interpretive communities, right? So notice where Laura ended. She said something very interesting. She said, realizing that the costs are not mine to bear, I suggest that courts should situate themselves as part of an interpretive community, right? So I want to think about a little bit about what that means, right? So I'll put that there as my larger purpose. But notice for a minute what Laura's done in the picture she's drawn, right? With the kind of well-known examples of appropriation. This is a term we see almost every day if you follow the cultural press in any form. She's given us a picture of society and the acts of creation that make up the public sphere that we all live in that is very different from a certain liberal notion of atomized individuals working as formally identical beings that come together to make claims in an impartial court. She's actually given us a picture of the public sphere as made up of groups riven by politics and power, separated by identities and brought together by common practice. So this is two models of society that are already competing in some of the descriptions she's giving us. Second, she wants us to think about fair use, and she opened by saying that she wasn't going to go over that, but let me actually just read one definition. Copyright law gives authors certain exclusive rights to their work, but fair use doctrine, codified in federal law as 17 U.S. Code Article 107, is a defense that allows another author may make limited use of the original author's work without asking permission. Without asking permission is really key to the first point I want to make, which is that copying is fundamental. I'll make 3 claims about what's really fundamental here in my reading of Laura's piece. Copying is fundamental, and as Dan knows, we've been having this conversation for a long time. To me, I'm interested in why copying is fundamental to developing countries, or what we prefer to the terms developing and developed, or global north and global south. When we talk about IP, we like to talk about low bandwidth populations, and this can be anywhere. This can be in Central California, in Bakersfield, it can be in Appalachia, it can be Louisiana, it can be in India, but Bangalore might be more connected than Appalachia. So we like to talk about low bandwidth populations when we talk about IP, and the other key word there is piracy. So I'm part of an interpretive community where we talk not just about piracy as a right to copy, often in violation of copyright law and sometimes on the edges of fair use, which has erupted over the last 10 years into, I think, at least 3 waves. You had a sort of defense of certain kinds of copying, and we had liberal interpreters like Lawrence Lessig. We had then a kind of post-colonial wave of post-colonial piracy that asserted what I've called a standpoint epistemology of the pirate, in which we kind of elevated the figure of the post-colonial pirate to a defiant proletarian subject on the margins. And then we have a third wave in which we question that rather simplistic kind of resistant subject. But I want to suggest that what's going on here is the fundamental right to copy and alter on the part of disenfranchised subjects of some kind. So that's where I want to get to Laura's footnotes. Notice Laura's footnotes, some of which she talked about, but many, many more in her very rich written version, suggest that every one of these questions of appropriation and fair use are laden with considerations of gender, race, socioeconomic status, sexuality, and power. So if I'm sort of footnoting the things I'd like us to talk more about, one is, can we say more here? Let me give you some examples. One of the footnotes is to Madhavi Sundar, our colleague up at UC Davis. Her work, as well as her work with Anupam Chandar, note that the public domain has given us a kind of free set of things to draw from. So in their famous article, The Romance of the Public Domain, they notice that it's very convenient that we valorize the public domain exactly at this moment where we want to draw resources from a free place to make private resources. So there's a whole discussion there about the public domain with Sundar and Chandar. There's Laura's own work on the reasonable observer, which leads us directly to think about the problem of hegemony and universality. Since I've got the notice, I'm going to jump straight to my second point. If my first point is that low bandwidth copying is fundamental, my second point is that the stories of hegemony under these stories of copying are fundamental. So hegemony and power are fundamental to our analysis, and the reasonable reader is always shot through with contradictions of hegemony. So that's what I meant in my opening suggestion by saying the reasonable reader, when taken apart, as Laura does very carefully, lead us straight to questions of hegemony and power. So my third point, through the notion of interpretive community, in which Laura calls towards the end of her paper for a conversation, again, a deceptively reasonable call. Right? But I think a very difficult conversation. So my final set of questions are going to be, how do we have this conversation? If you've read Sundar and Chandar's Romance of the Public Domain, they do something really interesting. They're always very practical in their ending. It's not just a critique of the public domain, nor is it a critique purely of privatization. They call for an in-between space. In between spaces which are neither purely public nor purely private, and they talk about how we might develop that. So my question relatedly is going to be how we talk about some in-between infrastructures for this conversation. Let me elaborate. Let me elaborate on what I'm calling for. Laura says courts need to, emphasis on need to, situate themselves as part of an interpretive community. The way around or under or through Fisher's relativism problem, which you suggested, actually has been shown to us by a number of competing interpretive communities, feminists, post-colonialists, people with political stakes in that story about how things are read have offered responses to reader response theory. But where did that take us to in recent literary history? To a complex and productive conversation about critical theory and its role in literary theory. It's been productive for us as scholars, but this is politically fraught terrain, as anybody knows if you've ever been to any kind of conference which raises these kinds of issues in an academic context. There are lifelong struggles and feuds and enemies and all kinds of things that happen because these are really politically fraught. I'm not sort of making light of academic feuds, but this conversation for individuals who have forged these schools of thought have merged advocacy, activism, and the production of knowledge itself. In other words, it brings together worlds which are potentially in conflict. The outside world of politics and the inside world of reasonable liberal thought. And I'm bringing this up because we stand at a moment, not only in this country, but all over the world, where precisely that conversation between a history of liberal persuasion and reasonable discussion is coming into direct conflict with a politics of advocacy and nationalism. So how would courts even begin to be part of this? Going back to Laura's point, the costs are not mine to bear, but it needs to happen. So I want to think, as Chandar and Sundar urge us to in much of their work, to think about in-between infrastructures to enable that. So I'm not just irresponsibly saying here, this is an impossibly hard conversation, so we can't do it. I'm saying, can you help us think about how we do it? Right? Let's talk about practices of having that conversation, because I share with you the belief that this is a really critical conversation, but I don't know how we should have it, especially at this point in history. So how do we read, say, Sullivan's appropriation of Loch Lomond as different from Schutz's or Prince's alleged dehumanizations of their subjects, right? We in this room, I venture to say, read a political history when you give us those examples. We bring convictions to it that are an impure mix of our own identitarian, perhaps national or nationalist, both particular and universalist humanist commitments. We bring all of those things to our readings of that discussion. What should the courts bring? Especially because lawmakers, policymakers, judges bring a particular persona to that kind of discussion. Is that the same persona we bring to our interpretive communities? I would argue that these are very different from reasonable observers. We bring sometimes unreasonable things because my third and last point is that critical histories are fundamental. So copying is fundamental, hegemony and power are fundamental, and third, critical histories are fundamental. And those are interpretive communities that are very complicated and don't really fit with the kind of personas that courts develop. So going back to, I think, what you're asking us to, I think you want us to do something really radical at the edges of law and history. So I guess my larger question here is a methodological and disciplinary one. How do we bridge gaps in disciplines that in fact were constructed for a reason, to keep certain kinds of conflict away from each other? And I use that word impure. We bring certain impure convictions to your examples. Are you advocating this kind of impure conversation? And if so, what are the infrastructures with which we have it?
invite Laura back up. Kavita, don't go too far away. Maybe stay near her. Laura, maybe you'd like to respond from to a couple of points, and then we have time for questions. I'm going to let you take your own queue of questions, and I'm going to make sure people can use the microphone so that the webcast picks up the questions from the audience as well as the responses.
Okay. And I guess I'll need to put this back on, right?
Oh, you can sit at that one if you want, although I can't see you. That's more comfortable.
So thank you for that very thoughtful response. And I guess I only have to say that I agree with everything I think you said, right? So I don't find it to be oppositional in any way, which is that it is complicated and difficult. And to say that courts as institutions are necessarily engaging in readings in the same way that all these other interpretive communities are, right, is simply not the case, precisely because, as I said, the courts are in a position of power. They have the ability to declare this work as a legal matter, as transformative, right, which obviously doesn't prevent an aesthetic interpretation that's different in the art world, right, but it carries with it its own power and meaning. And so the question is then to, how, as you say, to bridge that gap, I think, between what the court is doing as an institutional matter and what we are all doing as a sort of societal and aesthetic matter in terms of our communities and what the rules of the game are. So yeah, I agree that that's a complicated question. But I think it'll ultimately be a valuable one. And I think that the idea that as courts start to try to figure out how to engage with these different views and how do courts sort of take them into account, even the mere acknowledgement of the fact that these contested interpretations are happening, I think would be a profitable thing. But I thank you for that very, very rich framing of the piece. I think in terms of questions, I mean, maybe consistent with sort of what we've been talking about, I would enjoy a conversation about some of the themes as opposed to sort of question and answer, because I think we've kind of come to the conclusion that we're not sure that we have specific answers yet to give. But I'd be interested in sort of, like I said, hearing the conversation around these points.
So I'm going to take this microphone around. It will not amplify you, but it will make it available, your voice available to the folks at home. So I'll start here with Jessica Silver.
Here, maybe I'll.
Yeah, just hold it here.
So Laura, I have two thoughts, and you brought up some of the things I was thinking about. So the idea that copyright should not be reasonable is startling. Like, of course copyright should be reasonable. The way copyright law should proceed should be in a reasonable fashion. But the problem with the idea that transformativeness should be reasonable is that it seems like that's where the First Amendment does all the work in copyright law. And we need the First Amendment to protect unreasonable speech and speech we don't like. And so there's something disconcerting about embedding a reasonableness inquiry into the First Amendment analysis. And so one of the ways I'm wondering, and I think it's difficult because when we think about it in trademark law, the reasonable consumer, I mean, judges are just terrible at making these determinations. And so there are two different ways you could think about what reasonableness means in the Acuff Rose case, for example. One is that there's just objectively a perception of something new and different in what the second work is doing, that it's not reasonable observer or that there's a community that sees it, but that judges can perceive something else going on. And that's different than sort of an average observer. I guess, or the other way to think about it is that, that reasonableness could be defined more in an expert, I'm uncomfortable with this, I will say, but in a more expert kind of way, the way it happened in Prince versus Cariou in the Second Circuit with the amicus and the expert testimony in that case, and that judges recognize that there's something going on, but then they're going to have to defer, as in patents in a Markman situation, that what is the depth and the breadth of the conversation that the two pieces are having with each other. But the idea that, so I think there's tension in the reasonableness inquiry and the First Amendment inquiry, and I think bringing that out especially in terms of the power dynamics in who's on the margins of the speech, would make a lot of sense for the paper.
No, I think that's very helpful. Yeah, just to respond, so I think what you say is a way of amplifying, I think, or rooting the question that I'm raising, right? Which was, what exactly does it mean to say it has to be a reasonable reader's perception here, right? And what I think we're trying to guard against, and I think perhaps we're all on the same page here, is to say, we're concerned about the judges themselves saying, we are reasonable readers here, right? And we bring to this interpretation a certain set of dynamics and background and that are going to be sort of cabinet way that might lead us to say, and therefore we don't see, these are unreasonable readings in a sense. And so I think that's the call to sort of look out to what's happening in communities, perhaps look to expertise, although that has its own issues, right? But to sort of broaden that inquiry. But rooting it in the sort of, the First Amendment concern, I think is helpful. Did you want to?
Well, I'm wondering what's the difference between deferring to an expert opinion and being part of an interpretive community. Those are different positions for the court to take. I think belonging to a community means to commit to certain kinds of ongoing engagements, sometimes fraught ones. Deferring to an expert means we will take this. So is there a difference? I mean, not putting us on the same page too hastily, but wondering if there's a difference in what we're calling for?
I'm very uncomfortable with the whole Mark Min expert.
Exactly.
Yeah, because I think the question is, right, what is an expert doing, right?
Yeah.
Is an expert, I mean, use the word deferring, right? And that's exactly the point, I
Yes.
think, right? Is the court saying, okay, well, the expert says this, so therefore we will take it? Or is
Yeah.
it the expert coming in, perhaps in the same way like an amicus brief does, right? Which is just to
Yeah.
say, here's a perspective
Yeah.
that you might not have been aware of or might not have thought about. It doesn't hold any sort of weight, except for its persuasive authority, in that sense.
Repeat practice could be a better way of thinking.
Yeah.
Question from Brooke Thomas, UCI Law, or UCI English.
Thanks very much. This is not only a question, it's sort of a commentary to provide a different perspective or a different interpretation of what is going on with the court and reasonableness. You used an analogy with tort law and the prudent man and so forth. It seems to me perhaps a more productive analogy would be with obscenity law, where you actually have people reading text. And so we had, for instance, and I will turn to the Ulysses case, initially banned because of the Hanlon mode in Great Britain, which looked at the effect, reader response, on the most vulnerable people in a society. And in Woolsey's decision, which then got rid of that in the United States, there's still a reader response mode of sorts, but the reader is no longer an individual. A reader is no longer the most vulnerable people, empirical people, but a standard of a reasonable reader. Mm-hmm. That's an implied construct. And it seems to me, it was interesting. Then Woolsey said, I will take this to two reasonable readers, and one he gave to to Charles Merrill, who founded Merrill Lynch, and another to the reviewer of the Saturday Review. So he actually had empirical people, but that's sort of just an anecdote. Important is this concept of the reasonable person, which you're getting then in both realms. And it seems to me, rather than Fish's interpretive communities, which is ultimately a pragmatic notion that goes back to Peirce's notions of the communities of the competent, which does have hegemony in our culture about reader response. It seems to me much more productive about what the court is doing with the reasonable man would be Wolfgang Iser's notion of the implied reader. The implied reader, which Fish completely does not understand, the implied reader is in part a textual construct. And so what we're working there with is not only subjective, it's not only interpretive communities, but it seems to me the court is working much more with some notion of an implied reader which is projected itself by the text itself in trying to understand then what this is transformative. So it seems to me that would be another way of bringing in reader response, which is a phenomenological understanding of reader response rather than this pragmatic interpretive community one.
Yeah, that's interesting. I mean, I'll have to give more thought to that. My first reaction is that, if we think of this in terms of the implied reader, then we have the question of, okay, so what are the constructs of this reader who is implied, right? And that, I think, raises some of the same questions that we've been talking about, right?
But again, it brings the text back into play. Because the implied reader is not just, what we're, an interpretive community, it is what the text itself is producing.
Simon Stern, Toronto.
So it strikes me that another way to contemplate that very question would be to think of the reasonable person in tort as some bare minimum level of competence. And if you take that view, you might think that expert witnesses could do some work here. Each of them would presumably take the position that they're articulating the views of some accepted set of readers. It doesn't have to be majoritarian, it doesn't have to be hegemonic, it just has to be some discernible interpretive community large enough to share some particular view. And in that case, presumably you'd end up in a battle of the experts in which each expert would be seeking to discredit the other's proposition that there is such a community of readers out there discernible from book reviews, literary criticism, etc. So I just wonder whether, one, that seems like a plausible way to you to make sense of what you describe as the reasonable reader. And second, what you might imagine such a battle of the experts to look like if it were to occur?
Yeah, that's it's a complicated question, because the other concern I have as well is the sort of stacking the deck, right? So, sort of contemplating that this battle is coming down the road, right? The creation of an interpretive community precisely to provide the evidence needed, right, around this. So, so I think what's challenging and interesting is trying to figure out a way to mesh sort of what we can take from the theory in terms of the interpretation and answering the ultimate question we're trying to answer, in the intersection of that with the framework and constructs of the litigation process, right? And so making sure that sort of the latter doesn't sort of overwhelm the former, I think, right? And I think that's perhaps what your question is getting to, right? So which is to say that I don't have a sort of brilliant answer for you on that, but I wholly recognize that the sort of battle that you're describing, might well start to overwhelm the question that we're actually trying to answer. I don't know, do you have other things to say
I
about
do. I
that?
have a number of hands up. So Dan,
Yes, sir, we'll go to
so
that too.
yeah, I want to briefly bring back an example you used right in the opening. So when Two Live Crew does a rap transformation of Pretty Woman, sorry, the publisher's objection is that this should not be in rap, right? Or when Coco Fusco defends abstraction in the Dana Schutz case, right? She's actually disagreeing with an interpreted community. So I want to point to the role of disagreement, and perhaps the last point was talking about this in this kind of very difficult battle. It's really crucial in interpretive communities to allow for surprising disagreement. Coco Fusco has been part of this in many contexts. She was part of an online community called Undercurrents in the first days of digital feminism, and she disagreed with everybody about these kind of virtual communities that we thought would be beyond race, beyond gender, and so on. So the purpose of disagreement and to raise difficult, bristling questions like she was defending abstraction in Dana Schutz against a lot of people who said this was appropriation. She said artists have a right to abstract. So what do we do with those difficult, often, thorny people who people don't like and don't like to include in your expert consensus? So again, if we take an amicus brief to be consensus, if we call on interpretive communities to represent themselves, those sometimes disenfranchised voices within, and Coco Fusco is not disenfranchised, but that particular position is at different times.
Right.
And that's why history is key, because that temporality of disagreement is something I'd like to reproduce, but I don't know how when we bring it to the courts.
If I could I know you had another point to make, but let me just jump in
No,
really
that's
quickly if
it,
I could
yeah.
on that, which is, the idea of sort of hegemony and power replicates itself in sort of how these communities make their voices heard in the first place, right? So if you have access to an ability to sort of get your voice in front of the court or make it heard in some way, present it in a form that the court is likely to respond to, right? That itself is a privilege, right? An example of privilege that not all communities will have, right? So it is very challenging. But anyway, I know you had another point to make.
No, I'll stop there.
So we've got lots of hands.
Yeah.
We're coming to the end of our session, so I think the last very short question is going to go to Betsy Rosenblatt from Whittier Law School.
I don't know if I deserve this distinction, but I want to suggest first that perhaps the most radical thing about this paper is its most modest thing, which is to indicate that there is a reader. And particularly in light of cases like VidAngel, where the purpose and meaning the court has said, well, the purpose and meaning of both things here is to entertain, and so we're done with the transformativeness analysis, regardless of any conception of a reader. And with that in mind, I wanted to poke on something that's been a bit of a saw for me lately, which is the idea that you seem to adopt that merely trying to get attention is not transformation. And I think in many interpretive communities, merely trying to get attention is deeply transformative and probably progress promoting, although that's contested. And so I wonder how your thinking sort of contends with that situation.
Yeah, so I think I think a lot of this is going to inhere for courts in the distinction that Tony Reese and other folks have written about. So how do we know when something's a derivative work versus transformative, right? And that phrase it comes from the court, Campbell, right? The sort of merely, you're doing this merely to get attention, to avoid the drudgery of coming up with your own stuff, right? You're exactly right that itself can be contested. So I'm invoking that because I think that probably is the phrase that a court trying to draw this distinction between an unlawful derivative work and something that's transformative is going to hang its hat on. But you're right that even there, that could be poked at, right?
So actually, we do have, given the very succinct question and answer, we can take maybe one or two more questions. So we're going to come back to Mark Rose, UC Santa Barbara.
Hi, Laura. Let me see where this comes from.
You're good. Yeah.
I'm good on the mic. Okay. I'm interested in the role of experts in these things. I've been doing expert witnessing for 30 plus years, and I think that it seems to me wrong to constitute the expert as some kind of an authority standing outside who will just dictate the answer to court or jury. Rather, it's the expert by providing, amongst other things, the most important thing that an expert provides, I think, in copyright infringement stuff is contexts, rather than simply direct interpretations. For example, in the Abies Irish Rose case in Nichols v. Universal, providing information about how commonplace the conflicts and the genres and the representations were. So in a sense, you could see the expert witness as helping to constitute the jury as a reasonable observer by providing information and education. And the judge as well, because the judge also is a reader. Of course, just one irony, the Abies Irish Rose case is the case that has Judge Learned Hand saying, let's get rid of expert witnesses.
Thoughts? I think, Anne-Marie, did you have?
I did, yeah.
Anne-Marie Bridey from University of Idaho.
Thanks. So I'm just wondering, Laura, if you can say a little bit about the relationship between markets and interpretive communities in the fair use analysis, because I'm thinking about the Cariou versus Prince case and the Second Circuit's opinion in that case, which I think has some fairly objectionable kind of class elements to it. And the court there focuses on the fact that they're very different audiences, right? That the market for Prince's work and the market for Cariou's work are very different markets. And I'm wondering if we saw in that case, or if the analysis lends itself to a privileging of one interpretive community over another. In that case, the sort of the privileging of the kind of fine art market over the sort of more anthropological documentary work and the audiences for that kind of work that would be Cariou's audience.
No, I think that's a good point. And I referenced Gilden and Green's work on this in the University of Chicago Law Forum, I believe. I think it's Fair Use for the Rich and Famous, I think. And so if you haven't read that, I commend it to you, which makes this point, right, which is to say that the court seems sort of taken by the fact that, Beyonce and whoever other celebrities are sort of by Richard Prince's work and other folks, but they would not, they'd be creating a very different market for Carrier's work, which of course, I mean, they can also afford to buy Carrier's work as well, right? So it's not necessarily a distinct market. I think it's an interesting question about the interplay between the fourth and the first in terms of that community. To the extent that the court is inclined to see art or works, and I use that term broadly, as sort of commercial pieces, commercialized, then a court, well, I think we'll see those two things as very tightly intertwined, right? That the idea that there is a market for the work itself tells us that there's a separate community for the work. I think I'd probably push back against that a bit, because I think the first factor is actually asking us to do something different. There's a student piece in the Berkeley Technology Law Journal about Carrier that actually makes the argument that the fourth actually should drive the first in precisely that way. It's a very nicely done piece, but like I said, I think there's a reason why they're distinct. And I think the first is shot through much more with these questions of sort of interpretation and reception as opposed to market-based distinctions.
Zar Saeed, University of Washington.
Thanks so much. This is an incredibly interesting project and a great paper. I take it that you're interested, and Kavita's response also suggests that there's a shared interest in the larger kind of sociology of reading in copyright and in art. And insofar as we've been talking almost uniquely about the reader as a constitutive role and about interpretive communities, we've been talking about identity at various different levels, but not as much about practices and the practices that constitute the various communities and identities and roles. And Brooke Thomas's point about Easer's implied reader makes me think about the wave of scholarship that followed Easer's first sort of salvo on that point. And the idea of an implied reader is really not about a role as much as it is about a practice, about using the text or engaging with the text in such a way as to find a reader there, right? And I worry that if we talk about the reader in a way that allows a judge or a jury to simply substitute judgment, right? We're not actually talking about interpretation as much as we are about sort of intuition. And when I transpose reasonableness onto that set of problems, what I think of is how in tort law, reasonableness means something because we fill it, right, as a standard with something else, either a statute or custom, right, or a set of practices. And so my question to you would be, what are the conventions and practices that ought to be used to constitute reasonableness and to constitute a relevant interpretive community? So when we're thinking about the implied reader, what does that mean to imply a reader, and what are the steps that are taken? And I guess I would encourage you to think about that. And your example of a title being an interpretation because we deem it so. Well, I think of that as an interpretive convention. I think it's a good example, but I think of that as a convention, and it's a step. So what are the conventions and practices, right? What's the doing as opposed to the how and the what as opposed to the who, if that makes sense?
Right, and I think, I mentioned Janice Radaway's work too. I think that's an important example of sort of interrogating the practices. I guess, from my perspective, I think I need to think more about the question in part because I think I take the position, as the conversation with Jess earlier indicated, that I'm not comfortable with the idea of imposing the idea of sort of reasonableness on the fair use inquiry, and so I'm sort of inverting that term a little bit simply to say that the court has to be reasonable by providing reasons, in a sense, right? And I don't mean to be sort of glib or cute there, but I do think that given the sort of the theoretical underpinnings here, I think it's difficult to say that there is a sort of unreasonable reading. It's just perhaps an yet unknown reading, right? And so the question of sort of what then, if your question is asking about sort of what practices make a reading reasonable or unreasonable, I'm not sure that I would necessarily use that term. I might say, what are the practices that bring a particular reading to light, right? Or that ingrain a particular reading or make it something that gains traction. And then I think that gets back to the questions we've been thinking about earlier about, so what are the questions of sort of power and other structural features that enable a particular reading to either gain that traction or come to light or don't, right? But I don't think I would necessarily at the end of the day then say that that therefore makes the reading unreasonable. It just makes it visible, I guess.
Yeah, thanks for that question. I think that really articulates nicely what my problem was with that, what I call the in-between infrastructures of how we have that conversation. Yes, it's a question of practice fundamentally. The way I asked it was how would courts begin to practice that? And those were reflected in a lot of the early questions. But your point also reminds us in Daston and Gallison's work on early objectivity, they point out that 16th and 17th century modes of objectivity were not just about the knowledge you produce and it's the way it stands up, but the actual persona of the observer. You constructed yourself as ascetic or pure or beyond beyond power, beyond favor from royal courts. And that proved the objectivity of what you produced. And so not only practices, but the personas involved in it would be my question, yes.
Fabulous. Well, there's a lot more to talk about, but we are down towards the end of our session. So let's give another round of applause for our speaker and our commentator. For those of you who are physically here, there should be coffee and some refreshments outside. The restrooms are just down the hall to my right, if you're not familiar with this building. For those who are tuning in on the live stream, we are set to be back for the second paper by Betsy Rosenblatt at 10 a.m., and so we'll see you at that time.